The Honourable Ruth Dyson.
Chairman, I'm trying to recall when the last time it was that this parliament had voting together the ACT Party, the Green Party. I think I've just about ruled out pretty well every opportunity that's happened before. ACT Party, the Green Party, United Future, New Zealand First, Labour. Is that all of it? And on the other side, National and the Māori Party. You'd think that with something as important to New Zealand and as widely supported across the political spectrum over the last 3 decades, that the Minister would think we've got a problem here. But the Minister is content, having done a sleazy little deal with the Māori Party, and that's the only way you can describe it. The Minister is happy to get this legislation progressed by just one vote, the narrowest of possible majorities. I thought that vote might go last night when Marama Fox of the Māori Party described what crops meant in her deal with the Minister. Unfortunately, the Minister described to the House what crops meant in the bill, and they were really different definitions. The Minister said crops is about vegetables or cereals or fruit. And Marama Fox said, no, crops is that, but also about ryegrass and pine trees. One of them is wrong. And actually, normally I'd say it'll be Marama Fox because she's new to the House and she's not in charge of the legislation. But actually, given the track record, I'd bet it's the Minister that's wrong. What? But that'll be the first case that is taken to court. The Minister says this is reducing bureaucracy and reducing litigation. The first case to be heard in court will be over the definition of crop, and Pure Hawke's Bay, who have been assured by Marama Fox that it includes ryegrass and trees, I think she'll be calling them as a witness. They were party to the process of discussion. They were party, not directly, but involved in the discussions to give quality advice, and they've been let down. I think Marama Fox will be pretty grumpy, and I've seen her being quite grumpy in this House. Be afraid is all that I could say to the National Party, because you shouldn't trick members on whose votes you are relying on. It's just wrong. The National Party is wrong about another thing. They're saying that this flawed bill will fix the housing crisis in Auckland. They say that's the point of it. Nick Smith's often up on his feet, quoting how many houses are being built now compared to how few houses were being built during the time of the Labour-led government. He's wrong. Let me give you a couple of examples, Minister. 2004, the RMA was going, and then the number of building consents issued over the whole country, 31,423. The number issued last year, 29,970. Which of those two figures is bigger? That's correct. The 2004 figure. And in Auckland, where we know we've got the worst housing crisis in the country, but it certainly has spread to other places, in 2004, again, when the RMA was operating, 12,115 consents granted. Last year, 9,930. Which of those two figures is larger? Correct, 2004. So the idea that these changes will fix anything is wrong, and the idea that the RMA in these areas is causing the problem is just wrong as well. The figures show that the Minister has made a big mistake. And that's what the Select Committee heard too. That's what the Select Committee heard day after day after day. Not from fringe tree-hugging groups, not from groups that anyone in this House would say were extreme, from a wide variety of organisations who made submissions, including Local Government New Zealand, including regional and district councils, Mr Chairman.
Ruth Dyson.
Including developers such as Fulton Hogan, including Fonterra, are these fringe groups? Including airport owners, the New Zealand Law Society and every environmental non-government organisation, they all opposed this legislation. It's a bill that's going to make it harder to get things done, not easier. The Māori Party had an opportunity, using their votes that caused the majority in this legislation, to make a difference. Make a difference not just for Māori, to make a difference for New Zealand. Huge power they were wielding with the minister, and instead they crumbled for a con. I'd be pretty upset if I was them, and I hope they are, because they don't deserve to be treated like that. The point that I've been making throughout other parts of the committee stage of this legislation is that this carries on the trend of the last 9 long years of a national-led government of reducing citizens' right to have a say into what happens in their area. I've had a recent example in my own electorate where an asbestos dump has been allowed in a residential area. Can you imagine it? Just a street, you drive up it, there's houses on either side, and there's now an asbestos dump there. The independent hearings panel that approved this did so on a non-notified consent application and specifically referenced the 2009 resource management changes and said the onus on the councils had been completely tipped on its head, that it was now no longer expected that councils notified. It now was expected that councils did not notify unless there was a really, really strong reason for them to do so. And having an asbestos dump in your street wasn't a good enough reason. That's what the Minister and his National Party colleagues, backed up by the Māori Party, have caused in New Zealand, when previously we had effects-based legislation, which of course could always be improved, but which was widely supported and understood in this Parliament and outside. Water conservation orders have been undermined. The Minister has significant rule-making powers, powers of appointments to the Environmental Protection Authority, extensive powers for them now that they haven't had in the past. Mr Chairman, I just want to make one final comment, and that's not on the frustration that most people bar one in this House feel about this poorly thought through, shonkily dealt with legislation, and that is that I find the commencement stages to be of real interest. No longer do we have an Act that comes into force on X date, we have an Act that comes into force on 3 separate dates. So that's in the commencement under Clause 2. As if this legislation isn't confusing enough, nearly the entire bill has been rewritten by the Select Committee. Bits have been added, huge number of amendments discussed during the last sessions of debate. So sub-part 2 of Part 1, Part 4 come into force on the day that is 6 months after the date on which this Act receives the royal assent. That's good. Sub-part 3 of Part 1 comes into force on the day that is 5 years after the date on which this Act receives the royal assent, and the rest of the Act comes into force on the day after the date on which this Act comes into royal assent. As if the deal wasn't bad enough, as if the flawed logic to this bill wasn't bad enough, as if the process that has been pretty mangled in this House wasn't bad enough, we have a commencement, 3 separate dates in the commencement of this legislation, which is just going to layer on confusion and frustration. You had an opportunity, Minister, to really make a difference in this space, to really improve the Resource Management Act, to get all the experts together, get their identification of problems agreed and get their solutions agreed, and this Parliament would have gone forward with some willingness. It doesn't matter which political stripe the Minister's wearing. If we do a proper process and get agreement, we could really have made a positive difference. Instead, what we've done is seen a regression in our progressive resource management legislation, added an opportunity for resource management lawyers to make big money, and denied the public their right to have a say into what happens in their community.
Mika Whaitiri.